Hearing in the appeal on the King on the application of PACCAR and others against Competition Appeal Tribunal and others.
Thank you. My lords, my lady, I appear for DAF with Mr. Gregory and new to our team, Mr. Semester. Mr. Kirby, Mr. Went and Miss Wilk appear for RHA, and Mr. Thompson and Miss Ayling appear for UKTC. We have a agreed timetable. I will aim to conclude the oral submissions for DAF by 12:30. Then RHA will present oral argument until about 2:35. UKTC will make their submissions until 3:40, with 5 minutes leeway as between the respondents, allowing time for a changeover. The reply submissions will be from 3:45 to 4 p.m.
Well, I'll try to keep people fairly strictly to those times.
My lord, yes.
We've got quite a bit to get through.
It's a tight schedule. I'm going to, if I may, take the judgments below and the written cases as read. There's obviously insufficient time to address all the issues, but we'll try and focus on some of the key points.
Yes, you can take it. We've read the written cases and we're pretty familiar with what the points are.
I'm obliged. I'll give references by reference to the electronic file or EF, but we won't need to turn up every reference. My lords, my lady, the primary issue on this appeal is a point of construction correctly framed by the Divisional Court at paragraphs 63 to 64 of their judgment, namely whether litigation funding falls within the statutory definition of claims management services upon that definition's first enactment in Section 4 of the Compensation Act 2006. To summarise, on this central issue, our basic contentions are, first of all, that litigation funding, whether provided alone or in combination with other services, falls within the plain meaning of the language in Section 4. Secondly, that language is the product of Parliament's deliberate choice to provide a broad and flexible enabling power to the Secretary of State to regulate the activities of what was then and still is an evolving sector. Thirdly, none of the interpretive tools which allow a court to depart from the plain meaning of the statutory language justify a departure in this case. And fourthly, we say the Divisional Court erred in adopting the interpretation of Section 4 which it arrived at. My lord, my lady, very briefly, the Court will be aware that UKTC, at paragraph 18 of its written case, has also raised a secondary issue in these proceedings, namely that its opt-out funding agreement does not satisfy the definition adopted in later legislation of a damages-based agreement. As prefaced in our letter to the Court on Monday, I don't intend to take up the Court's time on that issue and instead propose to rest our submissions on our supplemental skeleton, which we submitted to the Divisional Court and which is to be found at EF 535. I also don't propose to deal in any detail with the intervenor submissions, given that the Court has our written response to those submissions at EF 236. Turning to the legislative history of claims management services, the Divisional Court went through the legislative history at paragraphs 5 to 13 of its judgment, and at paragraphs 14 to 25 of our written case, we've set that history out with references to the bundle before the Court. Before I develop my submissions as to why litigation funding falls within the statutory definition of claims management services, it may assist the Court to see the definition in context. Just to look at it, and I will come back to it in more detail, but just so the Court has the outline. It is at 589, and you'll see from the, if your Lord, my Lord has that, at 589 one sees in the preamble amongst other things, it's an act to make provision for the regulation of claims management services. And then Section 4, in Part 2, dealing with provision of regulated claims management services. Section 1, subsection 1, is a general prohibition on providing regulated claims management services. Section 4.2b and 4.3 provide the definition taken together of claims management services, which I will come back to in more detail. Section 4.2e, one can see that to be a regulated claims management service, subject to the prohibition in 1, the relevant service must be prescribed by the Secretary of State. So that's stage 2. Section 6 provides that the Secretary of State can exempt individuals from the scope of regulation. And Section 15 provides for orders which bring individuals within the scope of regulation and which must be approved by Parliament under the affirmative resolution procedure, paragraphs 3 and 8 of paragraph 15. The first order under Section 6, which deals with exemptions, must be approved by Parliament under the affirmative resolution procedure set out in subsection 7. And after that, orders expanding the scope of exemptions are subject to the negative resolution procedure we see in subparagraph 9. So that is the statutory scheme in the Compensation Act, which is central to this appeal. And I will come back later to the 2 orders made under the 2006 Act. Your Lordships will have realised that the reason we're here today is that a series of legislative developments since 2006 have piggybacked on the definition of claims management services in the 2006 Act. And by way of a quick canter through the legislation, if we could go, please, to EF 1671. This is the an extract from the Coroners and Justice Act 2009. You can see that it introduced a new section 58AA into the Courts and Legal Services Act 1990. And this provided for damages-based agreements relating to, at this stage, employment matters, and that they would only be enforceable if specified conditions were satisfied. And the court will see that in defining, you see in the restriction to employment matters in paragraphs 1 and 2, and then subparagraph 3 defines damages-based agreements. And you'll see in 3A2 that the amount of the payment is to be determined by reference to the amount of the financial benefit obtained. And you'll see some of the outline requirements in subsection 4 and regulations provided for in 5. And then you'll see at subsection 7 that claims management services is defined as having the same meaning as in Part 2 of the Compensation Act 2006, see section 4.2 of that Act, which we have just looked at. And then we don't need to turn it up, but for the Court's reference, the Lord Chancellor enacted regulations in 2010 and 2013 which added additional preconditions for the enforceability of damages-based agreements, or DBAs, under Section 58AA. For the Court's reference, those are at EF 661 and EF 664. Now, from January 2013, if we could just turn this up, at 1684, The Legal Aid, Sentencing and Punishment of Offenders Act 2012, and see in paragraph 45 that the restriction to employment matters, you can see in subsections 2 and 3, goes. It's no longer limited to employment matters. Just for the court's note, there is a rogue document at 635 in the authorities in the section on statutory materials. That refers to the Courts and Legal Services Act before this amendment in Lapso. And the correct document is now to be found in the supplemental bundle of authorities we've put in at page 2. So please ignore the document at EF 635. And then briefly, without turning it up, just to give the court the complete picture, in October 2015, the Consumer Rights Act 2015, which we don't have in the bundle, inserted a new section 47C into the Competition Act 1998, which we do have, which is at EF 608, but we don't need to turn that up for present purposes. That rendered DBAs relating to opt-out proceedings unenforceable, subsection 8. And again, the definition of DBAs was cross-referenced to section 58AA. That's paragraph 9, subsection 6. From October 2018, Section 27 of the Financial Guidance and Claims Act 2018, which is at 1679, transferred regulation of claims management services to the FCA under the oversight of the Treasury and reproduced the definition of claims management services in materially identical terms in Section 419A of FSMA 2000. And finally, for the sake of completeness, Section 90 of the Financial Services and Markets Act 2000, Claims Management Activity Order 2018, then amended Section 58AA to cross-refer to the definition of claims management services in FSMA 2000. Now, pausing there.
Sorry, what was the page reference for that?
Yes, sorry, it's EF 674.
Thank you.
Now, pausing there, we would like to highlight a few points. First of all, it is the post-2006 enactments that mean if litigation funding constitutes the provision of claims management services, the respondents' funding agreements are potentially unenforceable. Secondly, the meaning of claims management service is not affected by cross-referencing in or its incorporation into the post-2006 enactments. And the Divisional Court was therefore correct to focus upon the meaning of the definition as it was first enacted in the 2006 Act. And we don't understand that conclusion of the Divisional Court to be challenged by any party. And just to make good the point, it may be just useful to look at Lord Neuberger's judgment in Williams and the Central Bank of Nigeria, which is to be found at EF 1425. In paragraph 50, Lord Neuberger says, where a term in a later statute is defined by reference to a definition in an earlier statute, it seems self-evident to me self-evident that the meaning of the definition in the later statute must be the same as the meaning of the definition in the earlier statute. Hence, the meaning of the term in the later statute is determined by the definition in the earlier. Further, the adoption of the definition in the later statute cannot somehow alter the meaning of the definition in the earlier statute. Accordingly follows that one has to determine the meaning of the term in the later statute simply by construing the definition in the earlier statute. We also say that the meaning of the definition, if we keep that open for the moment, that case, we also say that the meaning of the definition cannot be affected by the anachronistic policy developments, academic writings or policy papers post-dating the 2006 Act, to which the respondents copiously refer. If one looks over the page in Williams at paragraph 53, see that Lord Neuberger says that he considers that self-evident statements made in the 1936 report and by the Solicitor General in Parliament in connection with the bill which became the 1939 Act must be irrelevant to the resolution of the first issue on this appeal. What a committee recommended in 1936 and what was said in Parliament in 1939 cannot, as I see it, possibly affect the meaning of a definition in a statute enacted in 1925. And in a concurring judgment with which Lord Hughes agreed with both Lord Neuberger and Lord Sumption, the concurring judgment, if we just go back to page 1420, this is the back end of paragraph 27 in Lord Sumption, just below letter C. His Lordship says, by adopting not just the language but the meaning of the ready-made definition in the Trustee Act 1925, Parliament directed the courts to discover its meaning in the latter Act. On that question, the intentions of a committee reporting 11 years later cannot be of the slightest assistance. And you see it from their judgment, but the Divisional Court was scrupulous in avoiding reliance on such material, and we would respectfully submit it was obviously right to be careful in that way. Nor, and we say that this is self-evident, can the meaning be affected by the expectations of the claims management industry, which has been aware of the nature of the construction issue we raise since at least 2014, even if no one took it seriously, and we give the references in our written case at paragraph 106. And to be fair, this all appears to be accepted, at least by RHA, who do make a number of references to what we would say are anachronistic materials or industry, academic and policy expectations. But they preface these by disclaiming that they provide an answer to the appeal, or they make clear that they may not assist, or they may not be directly relevant.
How does this fit with the principle that an ambiguity in earlier legislation can be resolved by later legislation? Could one not say, if the definition was ambiguous, the fact that it's used in a later act where it must clearly mean A rather than B shows that Parliament has treated it as meaning A, and that sets a legislative imprimatur on that interpretation?
I think the authorities would suggest that is a possibility if you discover an ambiguity in the earlier statute. Before moving on, I just want to mention Section 28 of the Administration of Justice Act 1999. That is at EF 580. This is the Access to Justice Act 1999, and at page 580, see provision is made in Section 28 for Section 58B to be inserted into the Courts and Legal Services Act 1990. This has never been brought into force. And we say that Section 58B, one can see this from subsection 3E, sought to permit a narrow statutory exemption limited to a specific model of litigation funding agreement from the common law prohibition on champity. as I say, this was never brought into force. I don't propose to say any more about this section now, but we'll come back to deal with it in a little detail later, because the Divisional Court placed some weight on it.
But I mean, it's right to observe that this is a statutory provision on the statute book by the time we come to 2006.
I accept that. It is on the statute book, it hasn't been brought into force, and the Secretary of State is under a continuing obligation to keep it under review. I accept all of that. And the real question is what interpretive weight one gives to it, and what impact it has in construing Section 4 of the 2006 Act.
Could it be suggested that the mischief had already been dealt with in 58B?
That indeed, or a mischief. It might be said, and this the Divisional Court thought, that Section 58B provided a comprehensive scheme, if brought into force, to deal with litigation funding. I'm going to have to address that, and I will. Lord, I was going to canter through the relevant principles of statutory interpretation, which I imagine that the Court is very familiar with. I'll try and take this quickly, but it might help just to pull some strands together. And we say these propositions ought to be uncontroversial. First of all, the Court must seek to ascertain the meaning of the words used by Parliament. We make reference to paragraph 27 of our written case. As part of that process, it is, we accept, proper for the Court to take context and mischief into account. But the language of the Act is the primary source by which meaning is ascertained. And I take that from Lord Hodge in Project for the Registration of Children at paragraph 29. We don't need to turn it up, but it's EF 1140. And as Lord Hodge made clear in the following paragraph, external aids may be helpful, but they play a secondary role. So we say that context and mischief do not represent a license to ignore the plain meaning of the words used. And that I take from Lord Neuberger in Williams at paragraph 72, which we set out in our written case at paragraph 27. And we say that there are only two principles which might be used to circumvent the plain meaning of legislation. Namely, one, a strained interpretation can be adopted to avoid absurdity or perversity. And two, greater violence can be done if one is in the territory of rectifying a plain drafting mistake. And I take that from my Lord Reid in Shahid and Scottish Ministers at paragraph 21, EF 1331. Now, one point I did not mention, we did not mention in our written case, is legal certainty, which ties in with Lord Neuberger's emphasis on plain meaning. And Lord Simon in Black Clawson, which is in the supplemental bundle of authorities at page 59, said this, that interpretation cannot be concerned wholly with what the promulgate of a written instrument meant by it. Interpretation must also be frequently concerned with the reasonable expectation of those who may be affected thereby. And I'm going to come back to that important principle in due course.
So the page reference?
I'm sorry, my Lord. It is Supplemental Authorities Bundle, page 59. And the internal page reference in Lord Simon's speech is 645, letter F.
Thank you.
As to the two principles from Shahid, which might be used to circumvent the plain meaning of legislation, I don't think I need to deal with rectification, because none of the parties to this appeal have suggested that the necessary conditions are satisfied in this case, as set out by Lord Nichols in Inco Europe. However, we do say that there are important limits on the availability of a strained interpretation. In particular, and we take this from Lord Simon in Stock and Frank Jones at 2992, if once context and mischief are taken into account, the statutory language is capable of only one meaning. A strained interpretation cannot be imposed. That's Lord Simon. And to similar effect, Lord Hodge in PRC BC at paragraph 30, page 1140 to 1. By the same logic, if an interpretation is proposed which has a meaning beyond that which the statutory language can bear, it can't be imposed as a strained interpretation and can only be imposed through a rectifying construction so as to arrive at the true meaning of the statute. Applying these principles, it is not our case that the court should apply a literal, acontextual interpretation to the words used in Section 4. Such an approach would have no proper basis in law, at least since 1584. Rather, our case is that context, mischief, and language demonstrate that in 2006, Parliament deliberately established a broad and future-looking enabling power that avoided loopholes and allowed the Secretary of State to protect consumers by regulating potential problems caused by various litigation services as and when they arose. Secondly, Parliament deliberately chose to cover a broad range of services, whether provided on a standalone basis or otherwise, with the use of an inclusive and clarificatory definition in Section 4 of the Compensation Act. Thirdly, in order partly to avoid legislative and regulatory overkill, Parliament ensured that use of the enabling power was subject to powerful statutory safeguards. Next point, all of this, we say, is reflected in the plain meaning of the 2006 Act. And we say, in the circumstances, the Divisional Court erred in adopting an interpretation which, in our submission, circumvented the plain meaning of Section 4. And what I would like to do, just to frame my submissions, is to break down the Divisional Court's analysis, because it had two central pillars and a third. And the first central pillar to the Divisional Court's analysis was this: dealing with the language of Section 4, the Divisional Court accepted that the provision of litigation funding could fall within the plain meaning of the statutory definition of claims management services. That's at paragraph 87, the judgment of the court below. However, it used the potency of the defined term to read down, or as Lord Justice Henderson put it, colour or condition the definition, such that it only captured financial services and assistance and the other services to which Section 4 applied, when those services were provided in the context of the management of a claim, paragraph 87. The second pillar, regarding mischief and context, Divisional Court found that standalone litigation funding did not fall within the explicit mischief that the 2006 Act sought to address, because it was not mentioned in the explanatory notes or the explanatory memorandum to the subsequent scope order. That's paragraphs 74 to 79 of the Divisional Court. And later it relied upon the liminal existence of Section 58B in the Courts and Legal Services Act 1990 as a further reason to find that Section 4 was not intended to enable the regulation of standalone litigation funding. That's paragraphs 88 to 89. And the Divisional Court added a final cadenza to its reasoning, namely that it would be absurd for standalone litigation funding to be caught by Section 4, as well as finding that absurdity would arise because standalone litigation funding did not represent the mischief at which Section 4 was aimed, and because of the liminal existence of Section 58B. The Divisional Court also found that Section 4, to capture standalone litigation funding, would give rise to, and I quote, legislative overkill, and that's paragraph 96. And my submissions are structured by reference to each of those three strands of the Divisional Court's reasoning. So if I may start with the plain meaning of the language used in Section 4 of the 2006 Act. If the Court could turn back, please, to Section 4 at page 589. We can start this at page 590. And see that bottom of page 590 is where Section 4 begins. And if we go to over the page to Section 4, subsection 2, see that 2B provides that claims management services means advice or other services in relation to the making of a claim. You'll see the broad definition of claim, very broad definition of claim in subparagraph C, and then E provides for services being regulated if they are prescribed by the Secretary of State. And then the second limb of the definition of claims management services you see in subsection 3, in reference to the subparagraph A, in reference to provision of services. A reference to the provision of services includes, in particular, a reference to, and then the Court can see that subparagraph Roman 1 includes the provision of financial services or assistance, and that's got to be in relation to the making of a claim if one reads 4.2b and 4.3a1 together.
On the face of it, that's not a gloss on the definition, because the definition doesn't refer to the provision of services. I would simply have construed it as affecting the interpretation of 4.1.
Yes, certainly services, where there's a reference to other services, that I would submit does involve the provision of other services, picking up the reference in 4.3. And in our submission, if one looks at 4.2 and 4.2b...
Do we have the whole of this Act anywhere?
I'm sorry, my lady.
Do we have the whole of this Act?
Yes, I believe so. Going down to paragraph, section 16.
What is the regulatory scheme that was in fact enacted under, or introduced under that? You're going to come to that.
I'm going to come to that. There are two relevant orders made under the 2006 Act. There's the scope order made later that year, and then the exemption order made a few weeks later.
Right, thank you.
And it's an important part of our construction, because I think it's common ground that those two orders are sufficiently proximate to be an aid to construction of the 2006 Act. They are regulations made under the Act, and they're sufficiently proximate. Could be said they're part of the same scheme. And so far as financial services and or assistance is concerned, there appears to be an acceptance from the respondents, and we would say the divisional court, that the plain meaning of the statutory language supports our case. If one takes 42B and 43A1 together. But aside from that observation, I just want to highlight a few additional points about the language of Section 4. First of all, in 42B, the disjunctive nature of that refers to advice or other services. And we say on the plain reading of this provision, there is no need to provide a combination of different services to fall within the scope of potential regulation. And it is potential regulation because one doesn't become regulated until a scope order provides for a particular service to be regulated.
Was the term claims management services used elsewhere in the Act?
In this Act?
Yes.
We've got the whole Act.
It's a definition which is of general application to the Act.
Oh no, we're missing a page.
And you'll see claims management services defined in the interpretation section at paragraph 14. Meaning given by Section 4.
But what I'm asking is whether the definition of claims management services had some effect, even if they were not regulated claims management services.
Yes, in our submission it does.
So where is a provision of this Act which affects people who provide claims management services, even if they're not prescribed claims?
Well, it's a trigger because if you provide claims management services, you are able to be regulated under the Act.
Yes, but when it's brought into FSMA later, there are some provisions in FSMA which just refer to claims management services.
Yes.
Not only
regulated.
The subset of regulated.
Indeed, that is correct.
Yeah, and what I'm asking is whether there was any similar instance in the 2006 Act where the broad definition, which you say is not too broad because it only has some effect if they're then prescribed, whether there was also an instance in this Act where actually that broad definition was be effective.
In terms of being effective, I don't believe so. In terms of, obviously it's the starting point, but I don't believe as a freestanding point it appears anywhere else.
I've just done a word search of it, and all provisions concerned with claims management services refer to regulated claims management services.
Yeah, and the long title, page 589, says it's an act, amongst other things, to make provision for the regulation of claims management.
I don't quarrel
So
with
that was a difference that occurred then when it was incorporated into FSMA.
Yes. And indeed in the 2009 Act. We say that the anchor of the statutory definition is the nature of the services provided, not the identity of the service provider, hence the definition in terms of claims management services. Section 4 specifically includes activities that do not necessarily involve, in our submission, management or control of a claim, which is the touchstone for the statutory definition relied upon by my learned friends. For example, if one looks at subsection 3, a claims referrer may carry on a business model which does not involve any real element of management or control over the underlying claim. Their remuneration for so-called claims farming is often simply commission from, say, a firm of solicitors, and we'll see that from the explanatory materials we'll come to in due course. Equally, reference to advice in section 42B ostensibly covers advice provided in the course of business irrespective of whether the advice is ultimately taken and or whether the advisor has any control or management over any claim. For example, a barrister who only provides advice is ostensibly captured, and barristers in general had to be exempted by Section 4 of the exemptions order, which we'll look at. The same is also true for specific services prescribed in the scope order, which again we'll come back to look at. And Section 4.3a is an inclusive and clarificatory list, and it is notable in our submission that my learned friends simply gloss over that point. By way of example, both UKTC at paragraph 14.3 of its case and the RHA at 71 say that the broad definition in Section 4.2b, advice or other services, is ostensibly of uncertain scope. And my learned friends say that this is a reason to read down Section 4 in the manner favoured by the Divisional Court. But in our submission, the potential breadth of Section 4.2b is exactly why Parliament set out the inclusive list in Section 4.3a and also the exemption in 4.3b. These provisions are designed to provide a degree of clarity as to what does and does not fall within the broader definition. And it's in the nature of such definitions that they may expand the natural meaning of the term defined. The short point is that Parliament has mandated that in construing the statute, the defined term must be taken to include the things it declares it shall include. And I'd just refer the Court to the citation from the House of Lords in Dilworth in our written case at paragraph 38. And as UKTC correctly says at paragraph 14.3 of its case, the meaning of financial services and other assistance, i.e. the clarificatory sub-definition in 4.3a1, is not in dispute. Or, as our fiercest academic critic has put it, this is Professor Mulleron, of course a funder unquestionably provides financial assistance to a litigant. The reference for that is EF 3457, and with respect we agree. So we say that the meaning of the statutory language is clear, and the divisional...
What's included in financial services there? I mean, financial services now in FISMA is a vast range of...
In our submission, it's a term with a plain meaning in English. It's not to be given any technical meaning in this context. Simply means what it says. And there is no dispute about this limb of the definition. The Divisional Court accepted at paragraph 87 that the provision of litigation funding could, and we say clearly does, fall within that plain meaning. However, the Divisional Court went on to hold at paragraph 94 that the clear language of Section 4 must, in its phrase, be coloured and conditioned by reference to the potency of the term defined. Therefore held that the provision of the services referred to in Section 4 would only constitute claims management services if they were provided in the context of the management of a claim. That's paragraph 87, accepting Mr. Kirby's submission to the Tribunal and to the Divisional Court. And in that context, RHA and UKTC say that the appropriate touchstone here is a sufficient degree of control or management of the claim. Now, the problem in our submission with this is that in its understandable desire to limit the scope of financial services or assistance, so as to exclude standalone litigation funders, the Divisional Court paid insufficient regard to the fact that its required conditioning applied to all the various subcategories of services spelt out in 4.2 and 4.3. We go back up to 591 and the Section 4 of the Act. In our submission, there is no basis for reading these provisions down in this way. For example, advice in 4.2b, there's no basis for reading it down. For example, standalone advice might be given in relation to a claim, provided it's given in relation to the making of a claim. There's no reason to read it down. Ditto, in 4.3, the references to referrals or inquiries. There's no hint of any additional requirement of management or control. And coming on to the scope order, if the Divisional Court is right, you would also have to read down the services spelt out in the initial scope order under the 2006 Act. If we could turn that up, please, at 651. And you'll see...
Sorry, did you say this is the scope order?
This is the scope order.
Okay.
And this, you accept, was made sufficiently commensurately?
Yes, it's December rather than July, but I think in the context where it was clearly contemplated that there would be a scope order, I don't suggest it can't be taken into account. I don't think any party does suggest it's not sufficiently contemporaneous. It's an order made under the Act, and in our submission it is sufficiently contemporaneous. My Lord Sales will remember a case in which we were both junior counsel, Dahlia and Barclays Bank, where Lord Brown-Wilkinson said that to be relevant to construction, the order made under the Act must be made under the Act itself and must be sufficiently contemporaneous, and we wouldn't suggest this isn't sufficiently contemporaneous, nor indeed the following exemption order.
Well, I mean, quite the reverse. As I understand it, you're positively relying.
We do. Well, all parties positively rely on the exemptions order. In my learned friend's case, there's a bit more the explanatory memorandum to the scope order, but yes. So if one looks at the services over the page, so you see regulated services at 4.1 at page 651, and then at 652, the Secretary of State prescribes kinds of service which are to be regulated in 4 subsection 2. And if you glance down those, all of these would need to be qualified so that they only fall within scope if provided in the context of the management of a claim. For example, 4.3b and C. And if B were qualified, there's no obvious need to exempt barristers, certainly barristers simply giving advice in relation to a claim, as they were in the exemption order made the following month. And C, referrals, if you read C, it positively entails the possibility that the other person to whom the referral is made is the person with control or management of the claim, not the referrer. And D does not on its face entail that the investigator himself has to use the results or control or manage the claim. Likewise, going back to A, that carries no implications that the advertiser has to himself conduct any claim arising out of the cause of action. And as the explanatory materials show, or come to this, the business model of many claims intermediaries or claims farmers was to obtain referral fees from the law firms to whom such cases were referred. So no necessity of control or management in that context. And we say the touchstone doesn't work. My lords, my lady, we have set out our position on the potency issue in some detail in our written case, paragraphs 41 to 55. And orally, I just wanted to focus on 3 points. The first point is that we say the Divisional Court was wrong to find that the defined term, claims management services, carries any particular potency, and was wrong to allow that term to prevail over the clear statutory language in section 4. In making this good, can I ask the court to...
There's a sort of incoherence about the argument, because the expression claims management services is defined. It means what we're told it means. And the argument that that definition has to be read within a context is taking as a starting point that claims management services has some other meaning, which provides the context in which you read the definition of claims management services.
So it might have a residual meaning. Where it doesn't assist the court is where the term which Parliament has stipulated is to be included. It doesn't help you construe that in our submission. It doesn't help to limit what Parliament has mandated should be included within the concept of claims management services. Where it might assist is claims management services falling outside the specific terms which we are told should be included within that definition. And that goes to the weight that the defined term, or the potency that the defined term has. And that's where, in our submission, Phillips assists, looking at Phillips assists this court. If the court could go, please, to 1018. It's where the report begins. And then could I just ask the court to read the headnote on the following page at 1019 between B and D. And you will see that the Supreme Court held that, above letter E, that for the purpose of Section 72 of the 1981 Act, information within the description, technical or commercial information, must be regarded as intellectual property, whether or not it would otherwise be so regarded. And then if we go on to page 1082, you'll see there that Lord Walker sets out Section 72 of the 1981 Act, and you see at subsection 1, in any proceedings to which this subsection applies, a person shall not be excused by reason that to do so would tend to expose that person to proceedings for a related offence or for the recovery of a related penalty from answering any questions put to that person in the first mentioned proceedings or from complying with any order made in these proceedings. And you'll see subsection 2 provides that subsection 1 applies to the following civil proceedings in the High Court, namely, and then you'll see A, in proceedings for infringement of rights pertaining to intellectual property for passing off, and then different proceedings in B and C. And then importantly, the definition of intellectual property in subsection 5. In this section, intellectual property means any patent, trademark, copyright, design right, registered design, technical or commercial information, or other intellectual property. So, skipping forward, if we can, to the court's treatment of that definition, if we could go on, please, to page 1086. Paragraph 18, Lord Walker refers to the judgment of Mr. Justice Voss at first instance. He said the review of intellectual property textbook shows that there is no universal definition of the term, which is no doubt why Parliament has adopted a variety of definitions for different situations. And then Lord Walker looks at Bennion and refers to a clarifying definition. Just for the court's note, Bennion, the relevant reference to Bennion in the court's bundle is EF 1581, and one can see from that clarifying definition means the same thing as an inclusive or an exclusive definition. You'll see the extract from Bennion. And then term potency explained by Lord Hoffman in Dextra, and then just below letter H, Lord Hoffman said that if the terms of the definition are ambiguous, the choice of the term to be defined may throw some light on what they mean. And Lord Walker goes on to say at paragraph 20, just pausing there, paragraph 18, one can see the court recorded that the term intellectual property had no universal definition. Paragraph 19, the court noted the starting point must be the language of the definition in the statute. It recorded that section 72(5) involved a particular form of inclusive and clarificatory definition, and then, as you've seen, it referred to the potency principle in Dextra. And then paragraph 20 is important. The court considered the application of the potency principle, and paragraph 20, Lord Walker says, here there is no particular potency about the expression intellectual property, term being defined, because there is a general consensus as to its core content, which he describes, and then between letters A and B, but no general consensus as to its limits. And then below letter B, importantly, he says, but for present purposes, the essential point is that the definition in section 72(5) contains the words technical or commercial information. Parliament has made plain that information within that description is, for the purposes of section 72, to be regarded as intellectual property, whether or not it would otherwise be so regarded. And then he talks about such limited potency as there is in the expression intellectual property, and more generally the legislative purpose of section 72 in enhancing protection against unlawful trade competition may be of assistance in determining the meaning of technical or commercial information. It must be something, and I'll come back to that, it must be something in which a civil claimant has rights capable of being infringed, since infringement of rights pertaining to intellectual property is what Section 72(2)A is concerned with. The fact that technical and commercial information ought not, strictly speaking, to be described as property cannot prevail over the clear statutory language. Whether or not confidential information can only loosely or metaphorically be described as property is simply irrelevant. And we derive two important findings from this. First, there is no particular potency in the defined term intellectual property, because though there was a general consensus as to its core content, there was no general consensus as to its limits. And secondly, by including the words technical or commercial information in Section 72(5), Parliament made clear that information within that description is, for the purposes of Section 72, to be regarded as intellectual property, whether or not it would otherwise be so regarded. And the fact that technical and commercial information ought, strictly speaking, not to be described as property could not prevail over the clear statutory language. Now, just pausing there, the respondents try to make much of the reference by Lord Walker to limited potency, letter C. But one can see that this, in fact, came not from the defined term itself, but from the fact that 72(2) provided that Section 72(1) could only apply to proceedings for infringements of rights pertaining to any intellectual property. See that from page 1082, which we just looked at in the definition, the full text of Section 72. And you get that if we go on to page 1089 at the top, where Lord Walker says it's only if the information is indeed confidential in the eyes of the law that a claim for breach of confidence, that is, infringement of a right of confidence, can arise. So that arises from the general provision in the context in which it appears. So from Phillips...
So they're saying that there is some limit placed on technical and commercial information by the fact that you're talking about proceedings, so it must be the kind of technical and commercial information breach of which gives rise to...
I accept that. But that limit doesn't flow from the defined term itself, but from the context in the Act in which it appears. Now, we say that from Phillips, the Court can relevantly take two propositions. One, a term will have no particular potency if, even though there is a general consensus as to its core content, there is no consensus as to its limits. And secondly, if an inclusive clarificatory technique is used to specify what will fall within the statutory definition, any potency that the defined term possesses will not be able to prevail over the clear and inclusive statutory language. And we say that both propositions are engaged by Section 4 of the 2006 Act. As to the first proposition, consensus on scope, the term claims management services was and still is not self-explanatory. There is no consensus as to either its meaning or its limits, nor was there any such consensus upon the passage of the 2006 Act. And if we go to the judgment of the Divisional Court at 288, paragraph 91, beginning of the paragraph, Lord Justice Henderson says the term defined is the composite phrase claims management services, which its common ground was not a phrase with any established legal meaning in 2006. And then if we go over to page 289 and see in paragraph 95, three lines down, His Lordship said the concept had, of claims management, the concept had no standard or accepted legal meaning, in 2006. And then between letters E and F, His Lordship said claims management is not a concept with a clearly defined existing meaning. And this also appears to be accepted by my learned friend Mr. Kirby at paragraph 74 of the RHA written case. And that being so, in our submission, the phrase claims management services cannot have any particular potency. We also say that the reasoning is a fortiori in circumstances where nobody, after careful consideration, has been able to suggest a touchstone which captures both the core and penumbral cases of claims management services which are accepted to fall within the statutory definition. In particular, although the respondents rely on the concept of control or management, it's clear that the statutory definition expands well beyond those concepts, and neither can properly operate to restrict the scope of section 42B and 43A, still less the scope order, as I've already submitted. So that's the first point. That's the point on the first proposition from Phillips. There's no consensus as to the meaning or the limits of the phrase claims management services, and so it can't be deemed to have any particular potency. As to the second proposition, the effect of an inclusive and confirmatory definition, we say that Section 43A in the 2006 Act involves the use of an inclusive and clarificatory technique, namely the choice to specify 4 types of services which unequivocally fall within the definition of claims management services. And as in Phillips, we say that the use of that inclusive clarificatory technique here makes plain that services that fall within the definition of financial services or assistance in relation to the making of a claim constitute claims management services for the purposes of Section 4. The upshot of this is that even if the respondents can establish that the provision of standalone financial assistance in relation to the making of a claim would not ordinarily be recognised as a form of claims management services, which we say they cannot, this would in any event be insufficient to prevail over the clear and inclusive statutory language in Section 4. So that's my first point on the divisional court's reliance on the potency principle. We say that both propositions drawn from Phillips establish that the divisional court, in our respectful submission, misapplied that principle in reading down the plain meaning of Section 4.
But, I mean, it could be said that Section 4.3a is not in terms defining what is meant by claims management services. It doesn't say claims management services will include what is set out there. It's defining something which can potentially fall within the meaning of claims management services in Section 4.2b.
It's not an all-embracing...
No. So just to put the point against you, might it not be said that one can refer to the elements within Section 4.2b itself in order to determine limits as to what is going to be included within the relevant concept? Here, claims management services is the relevant concept for our purposes, rather than importing anything that could be described as financial services in a broader sense. So if that's right, then it may be that there is potency in the term used. Parliament has deliberately used those words. It may be that there's indicative information in other parts of section 4.2b. So it says means advice or other services. So then that takes you potentially, I'm not saying necessarily, but potentially into a sort of eustem generis sort of argument that you need to, although financial services can, and indeed is very broad as a concept, it has to be fitted within the idea here. And then you get at the end, in relation to the making of a claim, which again focuses things down. So it's not just any financial services. You know, just being a bank doesn't mean that you're providing claims management services. So I wonder whether the real force of the argument against you is focusing on section 4.2b and the indicators there, because it's section 4.2b which is defining what is the critical term, not section 4.3a.
Well, in our submission, the two need to be read together, and it is accepted that 4.3 doesn't provide a comprehensive definition. It doesn't say everything within 4.3 falls within is claims management. But what it does do in our submission is it's a mandatory direction from Parliament that, come what may, provided these are made, these services are provided in relation to the making of a claim, these are to be included within claims management services.
Well, but then to put against you the other two indicators, it might be said, and provided they can properly be described as claims management services, i.e. taking colour from that, and provided they're in the nature of, let's say, analogous to advice in relation to the making of a claim, again, potentially narrowing down what counts.
Yes. In our submission, there's no ambiguity about financial assistance, financial services or assistance.
Forgive me, I wasn't putting it in terms of ambiguity. It may be you're saying, oh, well, the points I've made can only arise if there's a point of ambiguity.
That is one of the points I make from Phillips, is that Parliament has given a mandatory direction that these particular services, subject to that one qualification of in relation to the making of a claim, are to be treated as claims management services. Right. And the point you're...
Sorry, just on that, if you're saying the points that I've put to you, the three indicators, only arise if, in the case of ambiguity about financial services, I'm speaking for myself, I wouldn't accept that. I mean, it goes back to the point I've been making, that what actually we're most concerned about is what's a claims management service. That's the operative concept on which the other things then depend. And I'm not sure that it's a legitimate form of reasoning to say financial services could be anything at all, therefore no ambiguity, therefore you can't have regard to the terminology Parliament has deliberately chosen, claims management service, to get some idea of what Parliament intended to fall within that concept.
If claims management services had a clear meaning, then that point might have, in our submission, more force. But it plainly doesn't, and everyone proceeded on the basis it didn't have an accepted meaning. So Parliament has chosen to provide at least a degree of certainty, which is that whatever claims management services it means, it at the very least means these four things. And once Parliament has given that direction, this is the point we make from Dilworth, it becomes mandatory whether or not, and this is the point, whether or not it falls within the natural meaning of claims management services. So in that sense, the natural meaning of claims management services becomes irrelevant, because the point of an expansive and inclusive definition is that it may well go beyond the natural meaning of the term.
And that I follow you, but that's why I was putting to you that this is not an expansive definition of claims management services. Isn't that a difference from the Phillips case? Phillips case, the operative statutory concept was intellectual property, and then Parliament says, whenever we say intellectual property, we mean this broader idea.
The same concept of includes was used in Phillips in section 72, and in our submission here one is doing the same thing, that whatever claims management services means, we, Parliament, are directing you that it will, at the least, include these specified items.
Yes.
I wasn't too sure about that on the Compensation Act, but it can be said, I think, that the Financial Services and Markets Act is rather stronger in your favour on that. Section 419A, because there it's made directly part of the definition.
Yes, indeed, it is. Just going back.
But how would how would that work in relation to 3A(2) at page 591? The provision of services in relation to legal representation. So then you would say, Parliament has said that any services provided in relation to legal representation amount to claims management services, even if ordinarily they wouldn't be. They're nothing to do with management. That makes it extremely broad, doesn't it?
It does, but providing that legal representation is brought in relation to the making of a claim, then in our submission it's called. There are two stages to this, because it needs to be borne in mind that this is just the enabling power.
Yes, but this is establishing the vires of any order
Indeed.
that comes in, and that's what Parliament is doing here. It's not just saying, well, over to you, Secretary of State, you just regulate whatever you think fit. This is Parliament limiting the power.
Yes, but we say limiting in a very broad way. And one gets that even more clearly from the scope order as to what was captured. And to answer my Lord Sales, going back to my Lord Sales point, it may well be, in the light of your question, that different terms are used for this type of technique. It might be that clarificatory technique is a more apt description than inclusive.
Yes, thank you.
The Benyon uses those terms at the page reference I gave the court interchangeably, but clarificatory might be a more appropriate term of art for the technique being adopted by the parliamentary draftsman.
And does 3A Roman numeral 2 capture the photocopying company?
3A2?
Yes.
Not the
Provision
photocopy.
of services in relation to legal representation.
Yes, the answer to the absurd examples given of the taxi driver taking the person to court and so on is that none of these particular services are prescribed in the scope order.
But it wouldn't be ultra vires, the Secretary of State, to make an order regulating the provision of photocopying services.
Well, I don't want to say never, because, I mean, for example, might pose strange examples, but for example, if it goes back to the bank example, or if a taxi service brought in a service which provided they would provide rides free of charge, providing they got a share in damages, there's no reason in principle.
We're not talking here yet about language-based agreements. This is looking at the definition in the context in which it was enacted.
Yes, and in our submission, the scope of the enabling power is extremely broad.
I remember being told by a solicitor once that the photocopier was the highest earning member of the firm. So it's not inconceivable that people might want to regulate the charging out of photocopying.
No. But bear in mind, my lady, in terms of the scope order, it's not just a question of the Secretary of State having a completely unfettered power, because there is the affirmative resolution procedure here, which is quite important. My Lord, I was going to, I'm conscious of the time, I was going to go to...
Can I just make just a general point? What's going through my mind is that we're in 2023, where we've got a well-developed industry which whose interests are affected by the outcome of this case. In 2006, I suspect the position was very different. the background was a common law that was extremely restrictive of this kind of activity.
Yes.
And though at that stage there would have been conditional fee agreements had been legalised, but damages-based agreements hadn't yet been made lawful. And I suppose, this is all pre-Jackson, and we're looking, other people here will know much more about this than I do, but I have a feeling that we may be looking at the early stages of a development, in which case one might think that might colour the approach that Parliament might have meant to take.
Yes, indeed. Plainly, in our submission, Parliament intended to take a fairly broad approach. But can I just go back to your Lordship's question about damages-based agreements? In our submission, I don't think this is in dispute, but in our submission, what had happened at common law by the 2006 Act was that damages-based agreements had in principle been had been permitted as a matter of common law. The debate between us, and you'll see this developed in our written case, is whether those were standalone funding arrangements or involved a much wider degree of services, which we develop in our written case. But the two key cases in the early to mid-2000s are Factortone first and then Arkin. Two judgments, I think, of Lord Phillips, which liberalised the matter of common law. And would have been, and I think both of the agreements in issue in those two cases were damages-based agreements. We say the services being provided are much broader than standalone funding, but we developed that in our written case. My Lord, I was going to go, looking at the clock, I need to make a move, to move on, but I was going to go to the case of Delaney and Staples, which my learned friends rely on, but it may be better if I come back to that in reply, depending on what use is made of it. My Lord, we do say that as a matter of statutory language, the Divisional Court's interpretation renders the definition in Section 4 vague and circular, and it renders much of the language used redundant. Because providing a service in the context of the management of a claim, as the Divisional Court says, is the requirement in paragraph 87, will always satisfy Section 4, such that the inclusive list in Section 4.3a effectively adds nothing. At the same time, the express carve-out in Section 4.3b...
Well, doesn't it say, isn't the purpose of it to say, if you're doing claims management services, then the scope of what you do that can be regulated includes these things, so that if you are providing claims management services and you have to be regulated, then the scope of regulation can cover everything that you do that's in subsection 3.
My lady, in my submission, subsection 3 tells you what is to be included within claims management services, not the other way around. So it mandates that those matters are to be included within the concept of claims management services for the purposes of the Act.
It does seem much clearer for you on the Financial Services and Markets Act. I'm not quite sure why you're not setting out your stall on that.
Well,
that is the legislation now in force, isn't it?
It is, my Lord. And we could certainly look at that.
643.
I'm obliged. At 419A, I think your Lordship is referring me to, where 419A provides the definition of claims management services, and you see that in this Act, claims management services means advice or other services in relation to the making of a claim, and other services includes, and then the same rider at the end of subparagraph 2. And I think
at the moment that doesn't seem to me to leave much room for reading down other services.
My Lord, I would accept that. I think that one agreement was made before this Act. One of the litigation funding agreements was made before this Act came into force, and one after. Certainly, one of them was made after the 419A came in.
But it's not your case, as I understood it, that the meaning of financial services or assistant is different in 419A from what it meant in Section 4.
That wasn't a part of our case. No, that's fair. But I gratefully adopt what my Lord Legate has said.
Well, you say you gratefully adopt it, but it's then inconsistent with part of your argument based on the 2006 orders, isn't it?
Primary submissions are based on the 2006
Right.
Act. That's fair to say. My Lord, just give me a moment. I'm just trying to cut my cloth to fit in my time. Turning to mischief and context and the admissible aids to construction, our case is that the contemporaneous aids to interpretation demonstrate that the plain language of Section 4 is there by design. In particular, we say that those aids demonstrate that Parliament's choice of words was deliberately broad. Parliament aimed to establish a future-looking enabling power that avoided loopholes and allowed the Secretary of State to protect consumers by regulating particular services as and when problems arose. And that power, in our submission, was broad enough to encapsulate financial assistance and financial services provided to facilitate claims, whether provided on a standalone basis or otherwise. The Divisional Court took a different view. It set out excerpts from the explanatory notes to the 2006 Act and the explanatory memorandum to the subsequent scope order, which identified the type of services which initially failed to be regulated. And having done so, the Divisional Court concluded at paragraph 79 that there was no suggestion in any of those materials that indicated that the regulation of standalone litigation funding formed any part of the explicit mischief that Section 4 sought to remedy. The Divisional Court doubled down on that conclusion at paragraph 90, suggesting that nowhere in the structure of Part 2 of the Act was there anything to suggest that Parliament intended for funding agreements which did not involve a significant element of claims management to fall within the ambit of Section 4, apart from, the Court said, the words in Section 4 itself. And we say those are not good points, and the starting point, we say, is that the funding of litigation, whether provided on a standalone basis or otherwise, falls within the plain meaning of Section 4.3.1, which I think UKTC appears to accept at paragraph 14.3 of its case.
Was there any provision as to what would happen with the overlap then between people who are regulated claims management services providers under this provision and those who were providing regulated activity or engaged in regulated activity under the FISMA?
Yes, that's covered in the exemption order, which, if I get time, I'm going to take the court to.
Because wouldn't people providing standalone litigation funding be covered as carrying out a lending financial service?
Some, yes, some would. But there is an exemption provision in the exemptions order made at the beginning of 2007. Now, the funding of litigation was an aspect of the relevant concerns at the time of the 2006 Act. And what UKTC say at paragraph 96 of their written case is that UKTC does not dispute the terms on which claims managers advanced money to claimants was a significant source of concern to the government in proposing this legislation, and that this is reflected in the statutory wording. We'll see that this is a concession rightly made when we come to look at the explanatory materials. As we say in our written case at 61 to 79, there is no basis to conclude that a standalone litigation funding industry existed or was understood to exist at the time of the 2000 Act being passed. And we've discussed this already, but we point out in the factor-tame that in the factor-tame and Arkin judgments, the funding provided in those cases was not standalone funding. It was provided in packages involving various aspects of management and litigation support. And we set that out in some detail in those parts of our written case I mentioned. And we say the divisional court was wrong to draw inferences from silence because its approach assumed the existence of a standalone litigation funding sector which didn't exist or didn't clearly exist. Second point is it doesn't assist to focus, as the divisional court and the learned friends have done, on the immediate target of the enabling power, i.e. the services prescribed in the scope order. We do not dispute that the services prescribed in the scope order could be described as activities typical of what might very loosely be called claims intermediaries or claims farmers, as one of the ministers described them in Parliament. But the difficulty with delimiting the scope of Section 4 by reference to those activities is that Parliament may, and quite often does, go further than the core identified mischief, which no doubt formed the immediate target of the relevant secondary legislation. Without turning it up, but just to give you the reference, this was the point made by Lord Reid in the Black-Clawson case at internal page 614, supplemental bundle, page 28, and by Lord Simon and Lord Diplock in Mounsell and Ollins, which is relevantly quoted by Lord Bingham in Spath Home at internal page number 385F, electronic file number page 1285. So we say that the enactment of a broad enabling power which was designed to be future-proof and to avoid loopholes is exactly the sort of case in which Parliament would seek to allow the executive to go beyond the core identified mischief or the immediate target of the relevant secondary legislation as problems emerged. And you can see that, we don't need to turn it back up, but you can see that from the scope order we looked at a moment ago, it clearly targets activities which might typically be associated with claims intermediaries or claims farmers. But interestingly, in relation to the services that are prescribed, there is no mention of financial services or assistance at all in the services identified in paragraph 4.2. Yet, we've seen that the 2000 Act expressly included provision of financial services or assistance within the scope of the regulatory power. And it's clear that, as UKTC accepts, the terms on which funding was provided was of concern. So while it wasn't the target of initial regulation, it's plain that the enabling power in Section 4 was broader. If we look at the explanatory materials in our submission, they support our case. If one goes to the explanatory notes to the 2006 Act, at EF 595, just a few references quickly, if I may. Paragraph 31 at 595, one sees that the legislative framework is flexible and allows the Secretary of State to designate a body to regulate claims management services, to establish a body to regulate, or to regulate himself. The Act provides the outline regulatory framework to authorise providers who would be required to comply with the rules and codes of practice. And then if we go to paragraph 34 over the page, the end of paragraph 34, one sees that only those claims management services that the Secretary of State prescribes by order under section 4.2e be subject to regulation. Secretary of State can therefore target regulation in areas where he considers there to be a particularly high risk to consumers. And then paragraph 35, one sees it provides a list. It's an inclusive list and suggests that provision of any one of those listed services would be sufficient to fall within the scope of the order, within the scope of potential regulation. And you see it says the list, which is not exhaustive, includes financial services. And then if we go to the explanatory memorandum to the scope order, page 654, if we go to 655, please, paragraph 7.1. Three lines down, you see claims management businesses make money from several sources, from referral fees from solicitors. You see picks up the reference to referrals in the Act, from commission on auxiliary services, the sale of after the event insurance, and then this, and sometimes from loans to their clients. Concerns have grown over the unprofessional conduct by those who are providing the service for commercial gain. And then at paragraph 7.6, scope order, page 656, definition of claims management services in the Act is wide to allow new areas to be brought within the scope of regulation where problems arise, and for areas to be removed from scope where problems subside. The intention is that the regulation be applied initially in the areas where there is the greatest potential for consumer detriment. So one sees the phasing in. I was going to take the court to extracts from the parliamentary debates, but they're referred to in our written submissions. I think in the interest of time I will skip over those and rely on what we say.
Are they admissible anyway?
Well, they are admissible in terms of context and mischief, but not as an aid to construction of the Act. I think just give you the relevant authority for that proposition. It's Lord Mance describes it as a rule separate to Pepper and Hart, and the reference for your lordships is recovery of medical costs for asbestos diseases, which is in the Supplemental Authorities bundle at page 110, paragraph 55, and then in the Privy Council Presidential Insurance, which is in the Supplemental bundle at page 76, paragraphs 23 to 24. Both are judgments by Lord Mance. And I think in the first of those cases, the recovery of medical costs, Lord Hodge agreed with the majority judgment of Lord Mance, so I don't think it's inconsistent with PRCBC. I'm sure my learned friends will be grateful to me for that citation, given the extent of the citation in their cases from parliamentary debates. But as Lord Hodge said in PRCBC, it is, on any view, and we accept, a secondary aid to construction. And probably lower down the pecking order than explanatory memoranda.
Well, at least the explanatory memorandum is laid before Parliament.
Exactly.
That's a start.
Exactly. Although when the court looks at our submission, when the court looks at the extracts, I don't think they say anything wildly inconsistent in terms of the explanatory memoranda, but they are helpful in giving some colour to those documents. My lords, my lady, if we could then just glance at 58B. Which is to be found in section 28 of the Administration of Justice Act, and the text for section 58B is at page 580.
Access to Justice Act.
I'm sorry, my lady.
The Access to Justice Act.
Did I say? Indeed, I'm sorry. Access to Justice Act, 1999. And as the court is aware, this has not yet been brought into force. And so therefore it hasn't actually been inserted into the 1990 Act as we stand here today. But looking back at 580...
Well, 23 years is not looking very promising for it.
No. That's why we say it's a dead letter, but I can't say that definitively based on anything in particular other than the length it's remained on the statute book and not in force. There's no reason to think the Secretary of State hasn't kept it under review, as he or she has been obliged to do over the years, but one can speculate as to why it hasn't been brought in, and I will say a few words about that if I have time. But one sees the language in subsection 1 is framed in permissive terms, and you see in 2 the definition of litigation funding agreement, and it's defined by reference to the type of service, not by reference to the type of entity providing the funding. That's important. But in order for a funding agreement to be enforceable under 1 and therefore for its terms to be regulable under section 3, D, the sum to be paid by the litigant must be calculated by reference to the cost payable to him, plus a capped percentage of the funder's anticipated expenditure. That's 3E. So it's a very limited type of funding agreement, obviously not applicable to damages-based funding. And the commencement provision is at page 582, section 108. And I'm going to run through as quickly as possible a summary of our submissions on section 58B. It's common ground that the existence of section 28 of the Access to Justice Act, which provides the text of 58B to be inserted if brought into force, forms relevant context for the construction of the 2006 Act. It's also common ground that absurdity may be used, as the Divisional Court appears to have done, to justify a strained construction of section 4. The Divisional Court correctly did not adopt a rectifying construction, and no party has argued for that result. But we say that the Divisional Court was wrong to use the liminal existence of section 58B as a basis for circumventing the plain meaning of the statutory language in section 4. We say that the Divisional Court erred in its reliance on section 58B in 3 key respects. First, the Divisional Court's finding of absurdity neglects the fact that section 58B and section 4 both require executive action to be effective, and that the possibility of dual regulation arising out of the enactment of section 4 was well recognised. Executive action is required to bring section 58B into force, as well as the detailed regulations to be made thereunder. See section 4, subsection 4. The potential for dual regulation arising out of section 4 was well recognised. For example, the potential for dual regulation arising out of the initial scope order was addressed by the exemptions order. That being so, we say that Parliament can be taken to have been content to allow the executive to address the parameters of potentially overlapping regulatory regimes in a coherent way. Subject, as ever, to the affirmative resolution procedure. Secondly, the Divisional Court's finding of absurdity also neglects this important fact: that its own interpretation does not avoid the prospect of 2 potentially competing regulatory regimes. The potential for dual regulation under 58B and section 4 is no reason to read down the latter act, because even if the Divisional Court were right in its construction of the 2000...
It's overlapping between 58AA and 58B, isn't it?
The argument at this stage is the potential overlap of 58B. That's the reasoning of the Divisional Court that I'm on at the moment. And what I was saying was that the potential for dual regulation under sections 58B and section 4 is no reason to read down the latter, because even if the Divisional Court were right in its construction of the 2006 Act, that construction would also involve the possibility of dual regulation. My lords, my lady, everybody accepts that litigation funding provided in combination with other claims management services could be regulated under section 4. But if that funding was provided in the manner envisaged in section 58B3E, the claims manager would also be liable to regulation under section 58B. So, in fact, the Divisional Court's reading down of section 4 would not solve the issue it purported to address. But consequently, we say the coherence of the overarching regulatory scheme is in any event dependent on the use made of executive discretion in respect of both Section 58B if brought into force and in respect of the powers granted by the 2006 Act, both to bring services into the scope of legislation of regulation and to exempt services. Our third point is that in failing to address the issue that it purported to identify, the Divisional Court's interpretation has the effect of frustrating Parliament's intention to provide a broad and flexible enabling power to allow targeted regulation where needed. Perhaps most obviously, Section 58B would not in its current form permit the regulation of agreements based on a share of any recovery of damages, which are, and this is common ground, the industry norm, and were the basis of the remuneration in Factortame and Arkin. On any view, Section 58B was and is not a comprehensive scheme for the regulation of litigation funding.
I think it's common case that they can't regulate litigation funding agreements that are damage-based. But I thought that it was suggested that under 58B, the Lord Chancellor could make them unlawful.
Well, it's, in Section 1, it says that agreements would not be unenforceable by reason only of being a litigation funding agreement. And then there's an exception. And the power to regulate is in relation to certain types of agreement, which includes that in 3E, which is not based on the recovery of a proportion of damages.
So what 3E covers is says that the litigant mustn't have to pay anything over and above the costs that he recovers as the successful litigant.
No, the reference point is the anticipated expenditure of the.
Yes, but the first point. Together, what is the first thing that is then together with an amount calculated by reference?
Yes, but that's costs.
Costs recovered from the other side.
Yes, but it's not on any view based on damages recovered.
No, I understand. I'm just.
That's my only point in relation to that. So if Parliament wished in 2006 to regulate the terms of agreements based on damages, funding agreements of that nature, Section 58B could not, contrary to the Divisional Court's reasoning, be brought in for that very purpose. But we do say, my lords, that when set in its historical context, it's unsurprising that 58B was never brought into force, because after its enactment in the Access to Justice Act, provisional enactment, cases like Factortame and Arkin in 2005 relaxed the rules on champathy, and thereby rendered litigation funding available on an even broader basis than Section 58B had envisaged. And in the words of Lord Brown-Wilkinson in the Fire Brigade's union case, we would endeavour to suggest that certainly by 2006 the liberalisation of the common law constituted a subsequent change of circumstances which rendered it inappropriate to bring in Section 58B. That's page 551C at EF 1221 of the Fire Brigade's case. so that by 2006, Section 58B had effectively been superseded by events on the ground, and the fact that ministers were under a continuing duty to consider whether to commence Section 28 doesn't change that practical reality. So in the light of the language and context of Section 58B and what it provided for, we say the Divisional Court was wrong to conclude that it would be anomalous or unreasonable, anomalous or unreasonable result for Section 4 to enable the Secretary of State to regulate litigation funding.
Section 58B, was that, there was no provision when claims management services were introduced. There was no additional wording put into 58B6. To
No.
include claims management services.
But in our submission, there's nothing in Section 58B to limit it. It's subject to the type of funding being provided.
Advocacy in litigation only coming as they're what's being funded.
Yes. Mm-hmm. Exactly. My Lords, I've run down the clock, but I'd better just give a reference to my Lady Rose, which was the exemption order, which I had promised to take you to, but it is at EF 1694. And it refers to exemptions for legal services providers, basically for lawyers and barristers, and also exemptions relating to FISMA. Lord, unless I can assist you further, that wasn't all I wished to say, but it's all I have time for.
Thank you, Mr. Thank you. Mr. Kirby.
My Lord, I think I have to do some movement, and I wonder if Mr. Thacker would mind if, in fact, I simply moved over to where he was addressing to save.
I think because I've got all my papers here, it'll probably be easier if I just pass out.
Oh, okay. Well, in which case, I think I've got to move to there.
Yes, you need to be in front of speakers, microphones, for it to be caught on our live stream feed. Don't worry, we're used to delays of furniture removals.
And of course, just at that point, my computer decides it needs to be reopened. Lords, my lady, can I indicate what I intend to deal with and what I intend to leave to my learned friend, Mr. Thompson, to deal with, and hopefully between the two of us we will cover most of the points. But obviously, no doubt all of us here also rely on our written cases, which we're grateful, obviously, you've indicated that you have read. The starting point is that Litigation funding, as we know, is now a very common aspect of litigation and indeed lies behind all of the present actions in the Competition Appeal Tribunal. So, I'm not going to deal with, because it is clear on the written materials, I'm not going to deal with the impact of this appeal, and I'm not going to deal with the court's endorsement of litigation funding, because it's fair to say that this particular point has never, it would appear, been raised other than in this case and another case decided at first instance at the time called Meadowside. And my lords will have seen that particular decision involved litigation funding within the context of, we would say, claims management, and therefore we say is consistent with the divisional court's decision. I'm grateful to my learned friend for dealing with some of the chronology of the legislation. There are just one or two points that I wish to add to what was otherwise a helpful and thorough examination of that. We refer to the chronology of the legislation. We actually provide a chronology, indeed, at page 213, and that chronology itself, I don't believe, is in dispute. What the Access to Justice Act 1999 did was introduce amendments to the Courts and Legal Services Act by introducing new sections, so a new section 58 and a new section 58A. So those are in relation to conditional fee agreements. This was all within a section of the Act dealing with the funding of litigation. As part of those changes, Parliament also introduced 58B. So one had CFAs and litigation funding. Litigation funding, albeit that section has not been brought into force, was therefore part of the new funding landscape. And of course, a lot of these changes came about because of the reduction in the availability of legal aid, and the introduction of conditional fee agreements obviously enabled solicitors to conduct matters without recourse to public funds. The Compensation Act, sorry, before I come to the Compensation Act, can I deal with how Section 58AA originally came in? Because it is important in terms of understanding the differences between 58 and 58AA. Now, in the rather obscure world of the law of costs, work done in employment tribunals is regarded as non-contentious business. No doubt a matter that would surprise some, bearing in mind the number of cases that have reached this court dealing with the disputes in employment tribunals. But that work is regarded as non-contentious business, as a result of which both solicitors and indeed claims managers are able to conduct employment tribunal claims, albeit that claims managers could not conduct proceedings in court, because proceedings in court would be reserved activities. So when Section 58AA was introduced, it was introduced and limited to employment matters. Now, my learned friend indicated that damages-based agreements were in operation by the time of the 2006 Act. We would say that they were not in operation, other than within what is anachronistically considered to be non-contentious business. So a solicitor was forbidden from entering into a DBA by reason of its professional rules and by reason of probably the common law also, but could enter into effectively a DBA, a contingency fee agreement, in relation to non-contentious business. So that might be, for instance, if a deal went through, so purely a real sort of non-contentious business, if a particular deal went through, the solicitor's fee could be calculated by reference to a percentage of the deal value. but that they were also entitled to conduct employment tribunal matters on that basis. And it's also fair to say that some adopted a particular model whereby a contingency fee agreement was entered into prior to proceedings being commenced. So Section 58A only refers to those providing litigation and advocacy services, but Section 58AA adds in claims management services because it was directed at those who were carrying out such or dealing with such claims in the employment tribunal. And so obviously the damages-based agreement regulations 2010, which are at page 661, were also only dealing with DBAs in relation to employment matters. Those regulations, and perhaps we just look at them just for a moment. So page 661 refer throughout to a representative. So those are the original DBA regs, and a damages-based agreement means a damages-based agreement which relates to an employment matter. The client is the person who's instructed the representative to provide advocacy services, litigation services, or claims management services. And then one has then the requirements of the agreement and the information to be provided and set out in the following provisions. When DBAs were extended to cover nearly all forms of civil litigation, obviously they necessitated the new DBA regs, and those are at page 664, again referring throughout to a representative. And indeed, it is important that we just have a quick look at these regulations, as these are the ones that are still in operation and were referred to by the divisional court as with regard to the somewhat peculiar use of the word representative when dealing with a third-party funder.
But also this idea of costs.
Yes, I was just...
The idea the representative costs is
yes. Yeah, it causes, well, I have no idea how it would be dealt with, because a funder is providing a sum of money with regard to the conduct of that litigation. They are not then spending hours at a certain hourly rate with regard to any monitoring of their investment. It is a pure financial arrangement.
So if it was not covered by a DBE, it would be a loan repayable with interest rather than on the basis of an hourly.
If it was not, if the sum that the funder was to receive was not to be a proportion of the damages awarded, it could be, as perhaps envisaged by Section 58B, it could be a multiple of the investment, or it could, as my lady's just indicated, or it could be the sum advanced plus interest at whatever rate that might be appropriate. But Section 58B would preclude a third-party funding agreement where the funder is paid with reference to a percentage of the recovered damages, because that would not be a lawful DBA under 58B. So one does have the situation, I've moving on about 20 pages through my speaking note, but one could therefore have the situation where if 58B was introduced, because notwithstanding the recommendations of Sir Rupert Jackson and the voluntary self-regulation of litigation funders, the government thought the litigation funding needed to be regulated. One could have the introduction of Section 58B. The consequence of that, if my learned friend's submissions are correct, is that one might be able to draft a litigation funding agreement that was that satisfied Section 58AA, but as soon as Section 58B came in, it would then not satisfy. It would be rendered unlawful pursuant to Section 58B, even if it was lawful pursuant to Section 58AA.
What's the principle that enables you to rely upon the 2013 regulations in order to construe Section 4 of the 2006 Competition Act?
My Lord, what I'm seeking to do is rely on certain matters that we submit, confirm, which are confirmatory of the interpretation that we put on Section 4. So it's not to rely on it in order for you to construe Section 4, but for the interpretation that was put on Section 4 or given to Section 4 by the Divisional Court. We say that that is confirmed by, well, frankly, everything that has happened in relation to the conduct of funded litigation over the course of the last 13 years. We say that there is nothing until this matter was raised in
the legal principle or the authority that says that you can look at subsequent regulations to confirm an earlier construction.
Well, my Lord, that was a point that I thought my learned friend accepted when he was referring to our submissions on the point. We simply say, we simply refer to it, these matters, as confirming the interpretation, not that they assist with regard to the interpretation.
So they're legally irrelevant in your submission?
Well, they're irrelevant to the interpretation, but if a particular interpretation is consistent with subsequent matters and the way in which Parliament and the courts have dealt with a matter, then one can take some comfort. One gets some confirmation.
I mean, either they assist with interpretation or they don't. I'm not sure that comfort comes into it. And you seem to be accepting that they don't assist with interpretation. So why are we taking up time with them?
My Lord, we were taking up time because, by way of background, it was necessary to actually see what the difference between 58A and 58A is and why claims management services are in 58AA. Because we are dealing with 58AA, albeit with the imported definition from Section 4.
Right, but I mean, the specific question was about the 2013 regulations.
Well, my Lord, well, it's obvious I need to move on. But, my Lord, so far as the 2013 regulations are concerned, if comfort is not a consideration, then I will move on.
What are they made under, those regulations?
The 2013 regulations are made under, pursuant to Section 58AA, I believe.
Yes, it's page 664.
Yes. As I say, there was a particular reason why.
I thought that Mr. Thankey did accept right at the beginning the proposition put to him by my Lord Leggatt, that if a definition is brought in to later legislation in circumstances where it's clear from the way that it's used in that later legislation that Parliament thought it meant a particular thing, otherwise it would not have used that definition, then it means that thing and always meant that thing in 2006. So that if if it does lead to absurdity, as applied in this context, then Parliament cannot have understood it to mean that, which may mean that it never meant that.
Well, we would certainly submit that Parliament cannot have understood it to mean what the appellant seeks to urge upon you, the interpretation that the appellant puts forward. We have put it, as I say, as a matter of confirmation rather than Parliament actually in 2013, for instance, Parliament actually looking at Section 58AO or looking at Section 4 and saying, well, it doesn't mean that. We don't suggest that Parliament actually considered in terms Section 4 when considering the 2013 regulations.
But then they did subsequently change the cross-reference to Section 4 to the cross-reference to Section 419A.
They did at that stage, and the background, obviously, and I should just make the point, as my own friend did, but just so it's clear, so far as Section 419A is concerned, that concerns UKTC's litigation funding agreement rather than our funding, the RHA's funding agreement, because our funding agreement predated the change. So I'll have to leave my own friend to deal with that particular aspect. So can I come to the Compensation Act itself and deal with that? You've obviously been taken to the section. What you have not been taken to, we submit, is a number of matters that form part of the background and the context for that particular section. Now, well, it was the 2006 Act followed on from a report prepared by the Better Regulation Task Force. It also followed on, and I'll take you to that in a few moments, it also followed on from a number of concerns at that time with regard to claims management. To a large extent, this had grown out of the abolition of legal aid for most litigation and the introduction of CFAs. And that gave scope for claims managers to step in and see what profits they could make out of the matter. So the Better Regulation Task Force was a report which was aimed at concerns about the have-a-go culture. And the report itself is on page 3290. And one can see, give me a moment. One can see that it makes express reference to the introduction of no-win, no-fee arrangements. So at 3295, towards the bottom right-hand corner on the right-hand column, developments in recent years, principally the introduction of no-win, no-fee arrangements, where the claimant only pays their lawyers' fees in the event of success, and the emergence of claims management companies have increased access to justice. But the concern with regard to claims management companies can be seen at page 3310. One sees at the bottom of 3310 Claims management companies came up as an issue at almost every meeting we held. Everyone called for the government to regulate the sector. Whilst claims management companies work in the litigation arena, they do not form part of a statutory self-regulated profession. For example, solicitors are members of a profession which is regulated under the Solicitors Act and the Courts and Legal Services Act. The role of claims management companies developed as a conduit between a claimant and a wide range of service providers. Those involved are primarily solicitors who are engaged in personal injury work, although clinical negligence is increasingly covered as well. If one then goes to page 3311, the next page, one sees in the first paragraph reference to there were few claims management companies around before 2000, but the access of justice reforms shifted the burden of funding personal injury claims from the public to the private sector. If you could skim down to the next paragraph, claims management companies take advantage of this system by gathering accident cases by advertising or direct marketing, administering the cases, and then farming them out to solicitors up and down the country. The companies earn their money by non-transparent and complex systems of referral fees and charges. And then in the next paragraph, the sector was characterized by hard sell advertising and direct marketing, which encouraged people to have a go even if there was little chance of actually achieving the large payout being dangled as an inducement. And then ultimately the whole sector was brought into disrepute and culminated in the demise of market leaders, the Accident Group and Claims Direct. Now, part of the background and the context to the introduction of the Compensation Act was not only this report, but also the decision of the Court of Appeal with regard to the Claims Direct test cases. Because what we see from the judgment in those cases is the modus operandi of Claims Direct, which included making loans to clients in order for them to then be able to purchase ATE premiums, or an ATE policy rather, being charged a very, very substantial premium, of which only a very small percentage actually went to the underwriters, and where Claims Direct itself then received most of the money, or those who it distributed it to. So if one goes to, in the bundle to 2502, 2502, which is within the judgment of Lord Justice Brooke, if one looks at paragraphs 16 and 17, one can see a customer loan of £1,312.50, and then down in paragraph 17, that the actual amount that was paid to the underwriters was very small indeed, and the rest was, in a sense, distributed amongst others who were involved in the provision of that policy. And Claims Direct...
What's being suggested is not only was Section 4.2 aimed at the actual existing deficits in this area, the mischief, but it was also broad enough to encompass future developments that might occur. And what do you say about that?
Well, we certainly say it was aimed at the problems that existed at that time. So far as future developments are concerned, we say that so long as it was within the context of claims management, then it will be covered, and that the Secretary of State will be able to make particular regulations that would enable such future developments to be covered, so long as it is within the context of claims management.
And what does claims management mean?
Well, claims management is the managing of a claim on behalf of a client for some or part of the duration of that claim.
And then why do you have to expressly exclude expert witnesses?
Well, because an expert, I suppose out of an abundance of caution, to exclude an expert witness in case it was thought that so far as the, let's say, the quantum element of the claim was concerned, that in effect that had been passed over to the expert. Which may indeed be what the position was as it happens in FACCAR, which is also one of the two authorities that obviously were well known of.
The Arkin case as well.
Sorry?
And in the Arkin case as well.
And in the Arkin case, I think indeed, I mean, in FACCAR, obviously Grant Thornton were involved. They weren't the actual experts, but they were involved in the funding of the expert. So far as those, I've got about 1 minute. So far as Arkin and FACCAR is concerned, we deal in our written case with regard to why we say that they weren't managing the claims, because those were the findings of the judge, that there was no control, there was no, they weren't involved in the decision making. And we deal with that in our note. I can take you to the references after the short adjournment if that would assist. But I'm conscious of the fact that it is now 1 o'clock.
Yes. Very well. In that case, we will adjourn now and resume at 2 o'clock.
Thank you.